Okay, so welcome back, everybody. I hope you went and got a nice cup of tea and have had a little bit of a break. So where we left off then. So we left off here with the case of McLaughlin, which kind of set the foundations for the development of the modern approach to psychiatric injury. We looked at the development of the law up until this point. So by way of a little recap, we looked at some of the policy issues involved in limiting recovery of damages for nervous shock. Some of those reasons include opening the floodgates, fear of fraudulent claims, problems concerning causation, the fact that we could suffer an indeterminate liability, where there would be no end points for claims to be made. And actually, any development of the law in this area was an issue for Parliament, not necessarily for the courts. We found that in order to bring a claim in nervous shock, there was a requirement of a recognised psychological illness. Mere grief or sorrow would not suffice. The condition of that illness must result from a sudden event or an immediate aftermath experienced by the claimant's own senses. So not a gradual realization, as it were. So if you recall in McLaughlin, the claimant wasn't at the scene at the time. She'd come to hospital after her children were involved in a road traffic accident. She saw them covered in dirt and blood, and 2 hours later learned of the death of one of her daughters. She suffered serious issues, and her claim failed at first instance, but on appeal was successful because her psychiatric injury was foreseeable, because the victims were close members of her family, and her proximity in time and space to the accident was established because she had witnessed the immediate aftermath. Okay, so we got up to that point. Now we're looking at what the current law is in terms of nervous shock, okay? And Alcock is the case that sets this out. So Alcock concerned a number of cases arising out of the Hillsborough Stadium disaster. Hillsborough, when it happened, was being broadcast live on TV because it was a football match. And it was being shown live. And if you can click on the link that's on the slides to find out more information about it. But essentially, 95, 96 football fans were crushed to death as a result of overcrowding. The police had let too many people into one of the areas, and they couldn't get onto the pitch when they realised they were being crushed because the defences stopped them getting on there. And a number of the claims were brought by relatives or friends of the people that had been killed, because they witnessed things like this. They witnessed people being pulled up to the upper seating areas to escape being crushed, and to essentially escape being killed. So as I said, Alcock was a landmark case. It was about 10 claims for nervous shock from relatives of the Hillsborough disaster. 400 people, along with the dead, 400 people were injured. South Yorkshire Police admitted negligence, but they argued that their duty was only to those who had died and were injured. It wasn't and didn't extend to those who were watching the events unravel on television. So the points that needed to be clarified essentially then by this case, because bearing in mind, remember, the claimants were people that had been watching this happen on TV and were relatives of those who had been killed. But the points that needed to be clarified was who could claim, how far did immediate aftermath extend, so some idea around what immediate aftermath meant, and could TV viewers claim? So that's what Alcock was looking at. Now, all 10 claims were rejected. They chose to follow McLaughlin in their approach. So thinking back to McLaughlin then, the victims were close members of her family, and the proximity in time and space was established because she witnessed the immediate aftermath. And by following that approach, Alcott came to the conclusion that psychiatric injury must be a reasonably foreseeable result of the defendant's negligence. And 3 relevant factors to establish the duty of care are that there must be a proximity of the claimant in terms of time and space to the scene of the accident. There must be a close tie of love and affection to the victim. And the claimant must have seen or heard the accident or the aftermath with their own senses. So the personal relationships were close enough for some of the claimants, but the scenes were broadcast in such a way that no individuals were capable of being identified. So foreseeability of injury does not of itself and automatically lead to a duty of care. So essentially, because although there were loved ones watching the events unfolding at Hillsborough, and although they had a close tie of love and affection, and there was a proximity in terms of the claimants being relatives to those who were there, the argument put forward, or the conclusion, that was reached, was that the scenes that were broadcast couldn't identify anybody. So therefore, they weren't necessarily seeing the accident concerning their loved ones happening, or that aftermath happening with their own senses, because there was no one reasonably identifiable in those broadcast scenes. Alcott carried on with the limitations in terms of the shock must be of a sudden incident. So there must be sudden appreciation by sight or sound of a horrifying event which violently agitates the mind. It has yet to include psychiatric illness caused by the accumulation over a period of time of more gradual assaults on the nervous system. So any gradual awareness of loss is not recoverable. This is exemplified in Sion, where a claim was brought by the father of a young man injured in a motorcycle accident. For 14 days, the father stayed at his son's bedside, watching him deteriorate. He subsequently fell into a coma and died. The father appealed against the decision to strike out his claim at first instance, and his appeal was dismissed. The court found that there was, from the time he arrived at hospital to the time that his son died, there was an appreciation of a slow deterioration in his son. The medical report described a process that was continuing for some time, and there was no sudden shock or sudden appreciation by sight or sound of a horrifying event. And in particular, the son's death, when it occurred, was not surprising, but expected. So Sion shows what an awareness, a gradual awareness of loss would look like, and that it's not recoverable. In Vernon, the defendant had been driving the plaintiff's daughters, but negligently caused an accident from which they died. And the plaintiff was called to the accident and claimed to have suffered post-traumatic stress. The defendant said the effect was explainable simply as grief, and the defendant appealed against the quantum of damages. And the court held that damages for nervous shock are not to be reduced for irrecoverable normal grief symptoms. So that still stands in terms of a gradual awareness of loss not being recoverable. It must be the shock, nervous shock caused by a sudden incident. However, in North Glamorgan NHS Trust against the Walters, The Walters baby suffered an epileptic fit following birth because the hospital had been negligent, and the baby would therefore never have any quality of life. The baby's life support systems were turned off with the consent of their parents, and the baby died in the Walters' arms over a period of 36 hours, and the Walters suffered severe mental injury. Now, the issue before the court in this case was, could recovery of a secondary victim be allowed if there was no sudden shock as per the Alcock requirements? In this case, recovery was allowed as there was progression of the event over 36 hours and the elements of proximity and causation were linked, and recovery could be allowed without any significant legal step. This was one drawn out event. So here, distinct from Sion, then and Vernon, where you had a gradual awareness of loss, there wasn't a sudden incident, and in those two cases recovery wasn't allowed. But North Glamorgan and NHS Trust did allow recovery where there was an element of medical negligence, and where there was an element of medical negligence, which we will come back to as we move through the lecture. So continuing with the Alcock, the claimant must exhibit sufficient phlegm and fortitude. If you remember, that comes from Borehill and Young, so that affirmed that statement in Borehill and Young. But if a normal person would have suffered shock, then the eggshell skull rule applies. So the effect of Alcock then is that a duty of care concerning psychiatric injury is owed where the claimant is present at the scene and suffered physical injury, the claimant is present at the scene and their own safety was threatened, or the claimant suffered psychiatric injury due to fear for others, and the psychological injury was reasonably foreseeable. It was due to a close tie of love and affection. The claimant was proximate in time and space. The claimant experienced the incident or immediate aftermath with their own senses, and there was a sudden shock. And Alcock also set down the distinction between primary and secondary victims, which we will move on to now. So in terms of primary and secondary victims, the idea, the notion was set down in Alcock, and it was then subsequently developed in Page and Smith. So in Page and Smith, the claimant was driving his car where there was an impact due to another driver's negligence. There was no physical injury, but the trauma reactivated the claimant's ME condition. He'd previously suffered from it, but the illness had subsided. But the car crash brought back the condition. It was held that he was a primary victim in a car crash. He was directly involved. There was a risk of physical injury, and the claimant reasonably believed that he was at risk of physical injury. It's not reasonably or wasn't reasonably foreseeable that he would get a specific illness, but it didn't matter. Some form of personal injury was foreseeable to the claimant due to the duty of care. So this case set down in terms of a primary victim is someone within the range of foreseeable physical injury, a participant in the accident. For primary victims, there's no distinction made between physical and psychiatric injury, and there's no requirement of normal fortitude. The eggshell skull rule applies. As a primary victim in this case, it was enough to ask whether the defendant should have reasonably foreseen that the plaintiff might suffer physical injury as a result of the defendant's negligence, so as to bring him within the defendant's duty of care. It's irrelevant that the plaintiff did not, in fact, suffer physical injury. And that's per Lord Lloyd of Berwick. In terms of a secondary victim for this case, Page and Smith said that a secondary victim is someone who is outside the range of foreseeable physical injury, so they're not in danger of being physically injured themselves. A mere witness, or one who arrives in the aftermath, think back to McLaughlin. A secondary victim requires normal fortitude, and the control factors apply. So they're the factors that we've seen from McLaughlin's, Alcock, and obviously what we're seeing here in Page and Smith. And the duty of care is severely limited. So in summary, what derived from Page and Smith was a distinction between primary and secondary victims. Primary victims are a participant in an accident. A secondary victim is a mere witness or someone who arrives in the aftermath. For a primary victim, there's a foreseeability of physical harm that suffices. And for a secondary victim, there's a requirement of normal fortitude and control factors from Alcock. Okay, so I'm going to leave that there. And I'm going to allow you to go off and get a cup of tea, another break, quick sandwich, stretch of the legs, and then we will come back for part 3.